I will talk to you about the impact of Brexit in international contracts today. What happened with Brexit for Italian, European, and English contracts? Can a party avoid contractual obligations which become more onerous or impossible to perform as a result of Brexit? Many businesses are wondering whether Brexit will constitute an event which operates to discharge parties from their obligation under commercial contracts. It is important to underline that unforeseen events which occur after a contract has been entered into may be used by a disadvantaged party to argue that performance of the contract has become impossible, illegal, or radically different from that originally contemplated, such that the contract has been discharged by the operation of the doctrine of frustration or by reason of force majeure or MAC clauses. The question of whether these types of clauses can be activated as a result of Brexit will depend on the wording of the relevant clause. It is improbable that the very fact of Brexit in itself would activate such clauses, absent specific wording. It is, however, possible that legal changes that come out as a consequence of Brexit and the impact of such changes might activate those clauses. In English law, an event which could not have been foreseen by the party at the time of entering the contract is generally called a frustrating event. A contract will not be frustrated merely because performance has been more expensive or because economic conditions have changed. For a frustration argument to be effective, it would need to be established that the occurred serious event renders performance impossible, or the obligation is fundamentally or radically different from what was agreed to when the contract was entered into. For example, currency fluctuations are less likely to be a frustrating event than an inability to source products that meet revised regulatory standards. We need to know that the doctrine of frustration is a narrow one, and the burden of proving it is onerous. There is a very little case law on the doctrine of frustration. One reason for this is that commercial parties have for many years sought greater contractual certainty by including express termination rights in contracts through force majeure or MAC clauses when an adverse event arises. What about the applicability of force majeure clauses in Brexit? Force majeure clauses generally operate as to excuse performance of particular contractual obligation on the happening of certain specified events beyond a party's control. However, there is case law to the effect that a change in economic circumstances which affects the profitability of a contract does not constitute a force majeure event in the absence of express wording. In the event the parties have not dealt the Brexit clause, one can see how it might be argued that this constitutes an unforeseen adverse event in contracts that were entered into prior to the Brexit. However, for more recent contracts, it will be more difficult to argue that this possibility could not have been foreseen, and for this reason, Brexit clauses have been included in commercial contracts more frequently in recent months. First and foremost, during the period of transition, we are out of the period of transition right now since January 2021. In an international contract between English party and European party, it is very important the provision in the contract of the Brexit clause because Brexit has the capability to affect almost every aspect of doing business. Parties often have in their contracts a term by which a party or both parties may be excused from the performance of the contract in all or in part, or be entitled to suspend performance or to claim an extension of time upon the happening of certain events. The best solution for some commercial contracts is to incorporate bespoke Brexit clauses to activate automatic changes to a contract. A Brexit clause might simply provide for a requirement that the party will seek to renegotiate certain relevant aspects of the contract, failing agreement on which the contract may be terminated. So that's why for such clauses to be effective and enforceable, it is essential to define the activate event clearly, such as the contract becomes unprofitable for one party, a change in law, regulation, or illegality, the substantial changement of prices as costs relating to tariffs or taxes, Another important issues are the legislative one. Even though the relevant UK legislation will continue to apply post-Brexit, the consequent legislative changes may have a significant commercial impact, and changes in law are inevitable with Brexit. A provision allocating costs arising from a change in law is important in contracts because this provision in a contract provides certainty by indicating which party will be responsible for the incurred costs due to certain change in law. Also, current tariffs that are in place, applicable corporation tax rates, applicable VAT rates and treatment, the level of complexity of current customs checks, and all issues to be considered in the contract. And for some particular contracts which cross-border implication is important, the consideration of governing law and jurisdiction clause. It is evident that there is no one single solution in those cases, and each contract and solution needs to be tailored for each individual business. Thank you for your attention.